Members of the committee, for those who don't know me, I'm a trial attorney. I'm licensed to practice in Maine, New Hampshire, Massachusetts, all of the federal courts in those states, the First Circuit Court of Appeals, D.C. Circuit, and U.S. Supreme Court. And I can tell you I do a decent amount of trial work specifically in this area. And I can tell you the thing that was most telling to me and should be most telling to everyone in this room is when the Assistant Attorney General, Ann Rice, said, this has nothing to do with the Second Amendment. And I thought, well, gee, that's really strange because that's the whole premise of this legislation. And she said, this is self-defense. Most of the self-defense cases in this state that are charged at felony levels are absolutely firearm cases. It absolutely is about firearms. And I think that says it all. They expect us to retreat. When they say it worked very well in this state for 4 decades, you might want to talk to Stuart Urey or Joe Brown or Dave Shaw or Ward Bird, and I could list the names all day. They don't think it worked very well. They don't think it worked very well at all. And to say that if this, if HB135 passes, that they'll still have that absolute right to self-defense, I laugh. I go, that is absolutely not the case. It's just plain not true. Obama tells us that he supports the Second Amendment. Okay? I guess you could believe him. Let's look at what he's done. What we have here still is an affirmative defense. And for those of you who don't understand the law, that means you get to tell the jury why what you did was justified. The key word here is jury. If you're in trial land, nothing for your life is good. It's incredibly risky. It's incredibly expensive. People, when they're charged in cases like this, lose their jobs. They say, well, this person pointed a gun at someone. It's incredibly expensive for these people and incredibly risky. And it's based on prosecutorial discretion. Discretion that's been abused again and again in this state. Regularly abused. I've had state troopers tell my client, your right to self-defense is your right to call 911. And they absolutely believe that, and that's how they treat them. You know, a very wise man said, it's not he who maketh the law that's a giver of law. And you guys are all going to be shocked. It's he who interpreted the law that's a giver of law. How many times have we come back as firearm owners to this legislature to ask you to amend RSA 159.6 over the years? Many times, 159 in general. Why? Because the courts were distorting it and twisting your meanings. Remember when chiefs of police were demanding fingerprints and photographs for licenses? And we said, well, the law doesn't say you can do that. And they smirked and they said, well, it doesn't say you can't. And so we had to come to you and ask for redress. And even after that, the bad chiefs have got around it. They're demanding driver's licenses, which they photograph them, and they get high-speed digital printers. They now have photographs. My point to you is that the abuse of discretion of prosecutorial authorities in this state is rampant, and it destroys people's lives. I make a good living from it. I make a lot of money from it. But you know what? It's what I call blood money. I hate taking people's money when they did nothing more than display a firearm or try and defend themselves. Stuart Urey is a great example. You guys are thinking, well, this is when you're out and about, when you're anywhere you had a right. Stuart Urey was on his own porch. On his own property. 5 men came after him, 2 of them convicted felon drug dealers. Stuart Urey had no record. He's one of the people who allows me to publicly share his story. Most clients don't want their story shared publicly. Stuart went through 2 jury trials and was going to go to a 3rd. Both of them found him innocent. They charged him with resisting arrest when they pulled him down the stairs and battered him. And they tried to say, well, he attacked us. And Stuart said, I fell down the stairs.
Attorney Dean, I would take it that you're opposed to this bill.
I am opposed to this bill, and I think that what people have to understand is how this affects people's lives. You say that, you know, that everything will still be rosy. We haven't heard one case of abuse of the current law as it is. And the really sad thing is when SB 88 passed, it started out as a really good stand your ground self-defense bill. They whittled it down to a little sliver of baloney, and that's what we got here. Today we have a dinky sliver of baloney, and now they're saying, oh, we have to take it back because we're going to have all these horrible problems. They told us when it passed we're going to have blood in the streets. I've heard not one case of abuse, and I see no person that can explain to me why in the world you should pass SB 130 or HB 135.
Thank you. Is there any questions for the attorney? Thank you very much.
And I'm going to pass out cards because I'm always happy to answer legal questions. Sometimes committee members don't understand how the law. I've heard, one representative say you guys are misreading it, and I would respectfully say that I'm qualified and I'm reading it correctly.
We're down to our last speaker.